Imagine this, you've got a clean record. You pay your taxes. You follow the law. And on weekends, you light up a little marijuana. Maybe for pain, maybe to relax, in your state. It's completely legal. Now imagine that, one day, federal agents show up at your door. Not because you broke a state law, but because you own a gun. They tell you that, under federal law, you're a prohibited person, just suddenly on the same list as violent felons, fugitives, and domestic abusers, simply because you used marijuana. And here's the twist. The Supreme Court has just stepped in. They're about to decide whether millions of Americans, people who legally smoke pot under state law, can still exercise their Second Amendment rights. This isn't some far-off debate in Washington, it's real. It's happening right now. And depending on how the court rules, your right to own a gun could vanish overnight. Because for the first time in modern history, the nation's highest court is being forced to answer a question no one ever expected would reach them. Can you lose your right to bear arms? Not for a crime, not for violence, but for smoking marijuana? Before we break down how this all started, and what the Supreme Court's next move could mean for every gun owner in America, make sure you subscribe to the Firearms Legal Desk. We expose the legal battles shaping your rights, so you never get blindsided by a case that changes the law overnight. Now, let's dive in. To understand how we got here, we have to go back to a man named Patrick Daniels, a quiet Mississippi resident who found himself in the middle of a legal storm. In 2022, Daniels was pulled over for a traffic violation. Police found 2 legally purchased guns in his car, but they also discovered marijuana residue. Nothing major, no trafficking, no violence, just trace amounts. That was enough for the federal government to hit him with a charge that's destroyed lives quietly for decades. Title 18, Section 922, G. 3 of the U.S. Code. It says that anyone who is an unlawful user of or addicted to any controlled substance cannot possess a firearm. And since marijuana is still illegal under federal law, it doesn't matter if your state calls it medicine. To Washington, you're still a criminal. Here's where it gets eerie. That law wasn't written for the America we live in today. T was born in 1968, an era of fear, paranoia, and propaganda, when marijuana was demonized as a drug that turned men into monsters. Back then, the idea was to keep guns out of the hands of addicts. But today, with 24 states allowing recreational use and 38 with medical programs, millions of Americans are caught in a silent contradiction. Their states say yes. Their country says no. And if they get caught in between, 10 years in federal prison. In August 2023, something unprecedented happened. Patrick Daniels' case landed before the Fifth Circuit Court of Appeals, and the judges did something few expected. They defied the Department of Justice. The court ruled that the federal ban on gun ownership for marijuana users is unconstitutional. The judges said there's no historical tradition of disarming people for non-violent drug use. And under the Supreme Court's own Bruen decision, the government can't restrict gun rights without a deep, historical precedent. That ruling hit Washington like an earthquake. Because if it stands, it could unravel an entire section of federal gun law. Now, the U.S. Supreme Court has stepped in, and what's about to happen could redraw the map of American gun rights. Because this case isn't just about Patrick Daniels anymore, it's about you, it's about every gun owner who ever thought state law was enough to protect them. If the court sides against Daniels, millions of gun owners could become federal felons overnight. Their rights gone, their record stained, their futures destroyed. But if the court sides with him, it could detonate the biggest legal shift in decades. One that tears down the wall between state freedom and federal control. And here's the part no one wants to say out loud. This case could force the Supreme Court to choose between 2 freedoms America holds sacred: the right to bear arms and the right to personal liberty. One of them might not survive what comes next. When the Supreme Court agreed to take this case, the news hit Washington like a thunderclap. But outside D.C., in living rooms, small towns, and gun ranges across America, it struck something much deeper. Because for millions of people, this isn't a legal debate, it's personal. Think about the numbers. More than 40 million Americans use marijuana each year. Nearly half of them live in states where it's completely legal. And many of them, veterans, small business owners, hunters, family men and women, are also gun owners. They've done everything right, they've passed background checks, they've trained, they've stored their firearms responsibly. But under federal law, every single one of them is a potential felon. Not for violence, not for crime, but for a technicality. For something as simple as relaxing after work with a joint. You could be a father in Colorado, a mother in Michigan, a veteran in California, and without even realizing it, you're one click away from being labeled a prohibited person. Because in the eyes of the federal government, your legal cannabis use makes you too dangerous to own a firearm. For veterans, the stakes are even higher. Take Mike, a former Marine from Arizona. He served 2 tours in Afghanistan. Came home with chronic pain and PTSD. His doctor recommended medical marijuana. Tea helped him sleep. It calmed his anxiety. It made him feel human again. But Mike also owns guns. The same rifles he once used to defend his country. Under federal law, that combination makes him a criminal. If caught, he could lose his right to own firearms for life. So Mike faces a choice no veteran should ever face: his health or his constitutional right. And he's not alone. Thousands of veterans across America live with that same impossible choice every single day. Here's the irony: state and local police don't want to enforce this law. They know it makes no sense. In states like Colorado, Nevada, and Oregon, law enforcement sees marijuana users as ordinary citizens, not criminals. But federal law doesn't care what your state thinks. And that means even if your local sheriff supports your right to own a gun, a single federal agent can still arrest you. And they have. In Florida, Illinois, and Mississippi, people have been prosecuted simply for admitting marijuana use while owning a firearm. No violence, no threat. Just words on a form. If the Supreme Court rules against Patrick Daniels, the impact will be immediate and nationwide. It would give the federal government a green light to target millions of law-abiding citizens. Gun owners in legal states could suddenly find themselves under investigation. Background check systems could be cross-referenced with state marijuana registries. Concealed carry licenses could be revoked overnight. And don't forget the precedent it would set. If marijuana users can be disarmed because they're deemed unreliable, who's next? People who take anxiety medication. Those with sleep disorders. Anyone the government labels as mentally impaired? That's not a stretch, it's a logical extension of the same argument. But if the Supreme Court rules for Daniels, the shockwaves could be just as massive. It would open the door for challenges against every federal firearm restriction that isn't backed by clear historical tradition. Gun bans for non-violent felons. Restrictions for medical users. Even red flag laws could come under fire. Legal scholars say it could be Bruen 2.0, a ruling that doesn't just shake the legal world, but changes how America defines dangerous altogether. Because if marijuana use no longer makes someone dangerous, the government's entire framework for disarmament begins to crumble. And that's exactly what has officials in Washington terrified. Behind the scenes, some in the Justice Department are already warning that a loss in this case could open a floodgate. They're worried it won't stop with marijuana. They're worried gun owners will start challenging every single disqualifier, from alcohol use to antidepressants, even to unpaid taxes or misdemeanors. Because once the court says the government can't strip rights based on lifestyle or stigma, that logic spreads. And when it spreads, it doesn't stop. So this isn't just about marijuana anymore, it's about whether the federal government still has the power to decide who's fit for freedom. Because when the Supreme Court finally speaks, the ruling won't just define one man's future. It could redraw the entire map of gun rights in America. But here's the twist no one's expecting. Even before the court hears arguments, one of its most conservative justices has already sent a quiet signal that could change everything. In the next part, we uncover the hidden tension inside the Supreme Court itself, and the surprising justice whose private words could determine the outcome of this case, before it's even argued. Inside the marble halls of the U.S. Supreme Court, 9 justices stand at the edge of history, and the nation's gun laws are hanging by a thread. Publicly, the court is silent. Privately, it's divided. Because beneath the robes, the ideology runs deep on one side, those who see gun ownership as a sacred individual right, and the other, those who view it as a privilege that must be managed for public safety. And between them, a razor-thin majority that could swing the balance of power. Chief Justice Roberts and Justice Kavanaugh, institutional conservatives, are cautious. They favor gun rights, but they also fear the chaos of dismantling too many laws at once. They remember the fallout from Bruen, how lower courts flooded with challenges, how judges struggled to define historical tradition. To them, this case is dangerous, a chance to clarify the Bruen standard or to watch it spiral out of control. That's the first fault line. Then there's Justice Thomas and Justice Alito, the architects of the Bruen Revolution. They believe the Constitution says what it means, and means what it says. To them, if marijuana wasn't grounds for disarmament in 1791, it shouldn't be grounds now. Their camp argues that federal overreach has gone too far, that Washington has built a bureaucracy of fear, stripping rights through paperwork and technicalities. For them, Patrick Daniels isn't just one man, he's a symbol. A citizen standing up to a government that forgot its own limits. But on the other side, the court's liberal justices see the stakes differently. To Justice Sotomayor and Justice Kagan, this isn't about liberty, it's about safety. They warn that expanding gun rights for marijuana users could make law enforcement's job impossible. They argue that impaired judgment and firearms are a deadly mix, and that Congress, not the court, should decide how to draw the line. And somewhere in the middle, Justice Barrett and Justice Gorsuch watch in silence, their opinions unpredictable, their votes priceless. Then, in early October, something unusual happened. Justice Clarence Thomas, the author of Bruen, made a subtle but chilling remark during a separate case. He questioned whether the federal government still had any historical basis for deciding who could or couldn't own a firearm. Legal analysts caught it immediately. T was a shot across the bow. A warning that the same logic used to strike down New York's carry restrictions could now be turned against the federal ban on marijuana users. Inside the DOJ, alarm bells rang. Thomas and Alito stand firm, and if Gorsuch joins them, a majority could form overnight. Arguments are set to begin in a few months. But already, every side is preparing for fallout. Gun rights groups are drafting challenges for what comes next. Federal prosecutors are quietly reviewing old cases. And marijuana advocacy groups, many of them apolitical until now, are suddenly finding common ground with the Second Amendment community. Strange alliances are forming. The lines between right and left, law and liberty, are beginning to blur. And all of it leads to one inevitable moment. A verdict that could shake the foundations of American law. When that ruling finally arrives, months from now, the country will hold its breath. If the court sides with the government, millions of Americans in legal marijuana states could become criminals overnight. Gun shops will be forced to turn customers away. Concealed carry permits could be revoked. And the DOJ will have the power to desadujose too impaired to own a gun, based not on action, but on assumption. But if the court rules for Patrick Daniels, everything changes. It would set a new legal standard, that personal freedom and private conduct, when non-violent, cannot be grounds for disarmament. It would open the door to challenges against every restriction that fails the historical tradition test. From background checks to red flag laws, every pillar of modern gun control could be forced to stand trial under the Second Amendment. So here we are, a nation divided by law, united by uncertainty. One case point, one man. And one question that cuts to the heart of American freedom. Can you lose your right to bear arms not for violence, not for crime, but for something the state says is legal, and the federal government says is not? Whatever the answer, the decision will echo far beyond Patrick Daniels. T will define what law-abiding means in America, and whether freedom still belongs to the people, or to the government that claims to protect it. If you believe these battles matter, if you want to understand the laws that decide your rights before they decide you, make sure you subscribe to the Firearms Legal Desk right now. We don't just report the headlines, we expose the legal fault lines, the ones that could shift beneath every gun owner in the country. Turn on notifications, because the moment the Supreme Court rules on this case, we'll be breaking down every word of that decision, and what it means for you. Because the fight for your rights isn't coming someday, it's already here.